Inaugural seminar of the third season of the Nathanson Centre's Legal Philosophy Between State and Transnationalism seminar series. The series is a collaboration between the Nathanson Centre, Osgoode, and the philosophy department, and we're grateful to all these entities for their support and for their funding. Today, for our first seminar, we're very lucky to have the illustrious Professor Per Zumbansen, one of ours. Professor Zumbansen is a professor of law, and he holds a chair, a Canada Research Chair in Transnational Economic Governance and Legal Theory here at Osgoode Hall Law School, where he's also the founder and the director of the Critical Research Laboratory in Law and Society. Professor Zumbansen holds a licence en droit from the Université de Paris 10, an LLB, a PhD, and a habilitation from the University of Frankfurt, and, as if it were not enough, an LLM from Harvard. He's published widely in leading journals, and his most recent book with Professor Graf Kallis, entitled Rough Consensus and Running Code, a Theory of Transnational Private Law, was just released and published by Hart Publishing earlier this year. So we're very lucky to have perhaps a bit of a primer on the book today. I don't know what shape the talk will take today, but if you have questions, if you've read the book, that might be a good opportunity to have the man here and to grill him a little. Per is also the co-founder and the editor-in-chief of the German Law Journal, and he's a member of the editorial board of the journal Transnational Legal Theory. And since the 1st of July 2010, he's also the co-director of the European Union Center of Excellence at York University. And today, he will speak to us about transnational legal pluralism. Today's respondent is the no less illustrious Professor Robert Way, who is an associate professor of law here at Osgoode Hall Law School. Professor Way completed his graduate work in international relations as a Rhodes Scholar at the University of Oxford, and his doctorate in international law as a Fulbright Scholar at Harvard Law School. And prior to joining Osgoode, Professor Way served as a law clerk for the Supreme Court of Canada. He was a clerk to Justice Gérard Laforêt. He articled at the firm Russell and Dumoulin in Vancouver, and he also worked as an associate in corporate and commercial law with the firm de Beauvois and Plimpton in New York. And his current research focuses on governance through public and private law in areas such as international business transactions and transnational litigation. So without further ado, I would invite Professor Zumbansen to talk to us about transnational legal pluralism. Just to remind you a bit of our ground rules here, Professor Zumbansen will speak for approximately, or will try to speak for a maximum of 35, perhaps 40 minutes. We'll have a short reply by Professor Way for about 10 minutes, and then we'll open the floor to question. And before that, we'll leave a little time for Professor Zumbansen perhaps to answer some of the points that Professor Way might have raised. And then we're going to try to dedicate at least a full hour to the discussion. So without further ado, Professor Zumbansen. Thank you.
Thank you very much, François. Of course, I hope you recognize the irony about the no further ado, no, after this introduction. Okay, thanks very much for having me. I once had the pleasure of commentating on a paper by Brian Termanar in this series, and I thought this would be nice not to have this opportunity to speak more than 5 minutes about a few things that I've been doing and to share them with you and then to hear what you think. So this is this paper builds on things that I've been doing for a little while now that mostly have to do with trying to understand the relationship between law and different understandings of the state. And there's two levels to that story. There's a very domestic story to it, which is we have a transformation of the state if we look from the emergence of the state and different models throughout the 20th century, and I've tried to capture that in a very rudimentary and probably highly contestable manner in that matrix over there. That's a domestic story that suggests that there is a transformation from a state that we could coin in the beginning. All of those things are highly, of course, arbitrary. The rule of law, then the welfare state, and then highly contested what model of state succeeds the welfare state. Attached to those different models of the state are types of law. And again, overly exaggerating, we would call the first type formal, then we would embrace some kind of substantive law, and then again, it's totally open how we would refer to the law as we now use it. What type of law is that? And so one of the terms that has been coming up again and again is that we might be dealing with procedural law. And what's behind the idea of procedural law, of course, is that the erosion of fundamental insights or goals of possible state interventions into society make room for more inclusive forms of law-generating processes. So the idea becomes that law facilitates a process that's in itself quite open-ended. And that now leads, of course, to a change in our perception of the law itself. And if we did at some point allegedly just fulfill the idea of a particular statute, either by adjudication or by interpretation by other forces, we would then say we just deduce a particular legal response from some kind of understanding of what the norm really wanted and what it stood for. And then we move into the messy state of welfare state adjudication, and judges and policymakers find themselves balancing no absolute rights one against the other. Now at the end of this process, we now are in between those. We still try to have some statutes that could just be easily applied, and we try to open processes where we can have as much as societal input as we can into lawmaking. And so a rather sober description would be that we are just experimenting. This is, of course, terrible for continental European lawyers to hear, because they would never expect that to be their job, and a judge even less. Now, what's really important about this is just a background scheme that you have to keep in mind, because it plays a role for the kind of argument that we now have to unfold, which is the law's future in a globalized world. That is what this is about. We will always operate with a particular model of the state, and that's why this might be just a starting point to talk about these models. But what's really important that you don't confound this matrix with a historical account. So the most important part of this matrix is that it doesn't mean that the welfare state succeeds, substitutes, and supplants and puts an end to the rule of law. It's just a new form of differentiation. The sociologists are much more perceptive about this, whereas we would say, well, the welfare state really is the dominant paradigm for a particular period in the 20th century, and it has basically pushed the rule of law to the side. None of that is true, of course. Same applies, of course, to the models of law, the types of law, and the methods of legal interpretation and legal argument. None of these things are gone. The question is all about the third column. Third column doesn't mean that we don't build on this, and it also doesn't mean that we don't work with what we've done so far. Our aim now is probably to assess what we ought to do with what has preceded our current time. The second background assumption that we just have to sort of have in the back of our mind is that there is a particular way of understanding law. And to define law would be not just the topic of a seminar. That would be rather preposterous. It's basically the work of, a very, very long time, much exceeding our time, and clearly the time of these 20, 30 minutes here. So that's why I've tried to identify a few dominant definitions, current definitions, of what we might think the law really is. And important about those 5 definitions is only that you might ask yourself whether you've been siding with one or more of these, or perhaps even with all of them. That's the first level of the question. And the second question level is, what about the 5th definition? That is sort of disturbing. What would this be? The other 4 are relatively straightforward. They come as no surprise. The last one is the problem. Okay, without further ado, I like that. Okay, now we'll talk about this. So topic of the paper today is that we have to engage with transnational law, and we have to find, we have to retrace that history of transnational law as a concept, and we have to bring it together with legal pluralism. So transnational law, of course, has many backgrounds and has already had many lives in the last few decades. But one of the starting points that lawyers often like to point to is a series of evening lectures that Philip Jessup delivered in Yale as part of the Storrs lectures. And for those of you who now come across the Storrs lectures for the first time, it's actually quite worthwhile to take them almost like a seismograph of American legal consciousness throughout the 20th century and look up some of the other Storrs lectures. It's really quite fascinating. Often these things are particularly poignant if you try to trace how an idea has been developing. So the Storrs lectures in many cases formed a pinnacle point in the development of legal thinking. So similar to the Storrs lectures delivered in the mid-50s by Philip Jessup, where he basically set out to say that transnational law, admitting that this is a term that is relatively difficult to gauge, will have to fill a gap that's left by both public international law and private international law, otherwise known as conflict of laws. Now, this is rather full-mouthed, and he goes into some detail trying to describe what this could be all about. The basis and the core of his little book and the lectures is really trying to work towards a legal concept and a field of law and perhaps even a methodology of law that captures border-crossing activities that could be between private and public entities. And it's not so schematic what he does. In fact, it's much more sophisticated, but it remains sort of just as an idea. And that's really prominent in the examples that he gives when he says we are dealing with governance issues that look very domestic, perhaps. For example, who makes decisions within a stock corporation? And then if you compare this, or if you now started to compare it with who makes decisions within an international organization, on its face, not only those questions have never been paralleled, but also the scholars working on them have never talked to each other. And he sets out to create a dialogue between these people. And he says, in what sense are the participation, representation, accountability, transparency, and perhaps democratic governance issues raised by, let's say, in international organizations are really very similar to the ones that you have domestically inside. So in some sense, it's a very pertinent contribution to what we will soon discover as globalization studies. No? It's pretty obvious that he talks about entities that are unfolding with a lot of disregard for national borders. And he says, so how do we govern them? How do we even start to think about those? What's really important also, what's just touched on in the book and has occupied scholars for decades afterwards, is the public-private divide. The corporation is, of course, a private entity. So we don't talk about democratic governance. We just talk about control of management so that they don't steal the investors' money. Whereas it's obvious, seemingly, that the international organization is a public entity. And he says, why is that so certain? If you look at the functions, the scope and the size of both entities, it's obvious that it's really difficult to pinpoint which is public and private, and both of them clearly fulfill a very vast public function. Okay, so what's really important to see is that the legacy of Jessup's and other people's work has been at best aspirational. No? It's highly fragmented. It has gone into a lot of different fields, but there's very little doctrinal, or there's very little official backdrop to this. No, you hardly have positions in transnational law, or you have institutes, no, and they are already looked and frowned upon by others if you have an institute in transnational law, because then nobody really knows. Like a normal lawyer doesn't know then what it is really that you do. Now, that's why it's important now to unfold the context. And as we unfold the context, and this is all what I will do now, it becomes more and more difficult even to find the place of law in this debate. No, the law is no longer the dominant discourse if we want to try to understand or work towards a theory of governance of globalization. So that's why I will bother you with a few eclectically put together definitions and perceptions of globalization, mostly by political scientists, by geographers, sociologists. So All of these things, of course, are well known, but they're noteworthy to remember. If this is all true, if globalization is really such an unwieldy field, then it's obvious that we can't just take it lightly. No? And if we are now talking about law in globalization, that means we somehow have to develop a methodology that helps us assess what this is really all about. Because it's one thing to have a Globalization 101 class when you're 17 and say, well, this is amazing how all these fields come together. But if this is not just ivory tower talk, an obsession of some people that think things have become connected, the world has become smaller, but in fact that it matters for the way we think about law, because that's really our our déformation professionnelle, that's what we care about, then we should take it seriously. That's what we will do. Okay. One of the important and always found again definitions is that globalization takes care of states. No political authority erodes, and the agency of the state is greatly diminished in processes of globalization. You all know that this is highly contested. People will say the exact opposite, no, but you have to decide to do with that. Also, the claims whether globalization is a good or a bad thing, or what makes globalization work, whether that's a good or bad assessment, all of that is for us to decide, really, no, because these claims are clearly coexisting. So that globalization comes over us like an inevitable force, almost that has a natural impact. People say that, and other people say nation states are the places where the work of globalization gets done. No, it's all made and produced. Some people will say there are maybe some bad beginnings about the current stage of globalization, but that will peter out somehow. And at the end, we will have a larger framework for a liberal society on a global scale. Some people say that. What's also very important, and that's something that judges have been dealing with for a long time now, and we as law students and scholars and practitioners have been doing that as well, is that processes that seemed rather distant and unrelated have become very related and very proximate now. And that's important. This is, of course, not the language that lawyers would use. They only recognize that the constellations that they deal with have become global in nature. So, just as a brief interlude, at some point, when you have your political awakening, you will have joined an anti-globalization movement, no? And then you went home and explained that to your parents, and they said, "But you get your work done at the same time, and don't you understand?" Da, da, da. So it's quite difficult, no, if you're being asked those questions, no, but that's really the intriguing part, no, to be against what. So if globalization is really what we just looked at the previous slides, then it's not so much a thing you can be against, no, or for. It's just the state of the world now. So you have to develop a different form of engaging with it. And that's really important to keep in mind. Okay, I'll just give you a few images that show how many different things are walking under the banner of being unhappy with globalization. So these are fairly obvious from recent times. But this already shows there's much more at stake. No? The single evil reason why a particular event takes place is much more difficult to assess if so many different issues conflict. And that makes up anti-globalization. Yeah, that's almost kitsch, but it's so real. No, it's not kitsch at all. Okay. So it's obvious now that globalization narratives that we as lawyers can either take on board and try to understand, or we just leave them aside and say this is for the social science people around us. They are still all of these things that I've put here. No, they're really difficult to put into one box, and they challenge us to put distant ideas together, but also to really understand these globalization eruptions as only as tips of icebergs, no, of much more complex developments that we should try to incorporate in our work. Okay, now, because we're rather pragmatic, and that's really how the human mind operates and how lawyers operate and how regulators operate, you can't just sit there and always think of a theory of the world. No, you will have to take on issues as they arise, and you have to try to find solutions to address them. And that's how the last few decades have been unfolding. We just add issues. And if you now, for example, if you look at this list of issues that a global society has to deal with, then you, of course, already see that it's not at all obvious what to do about them. But then you should remember the transformations of the state. And you should see how many of those issues really are already faced by the nation state, let's say, at home. And you will see that much of that, of course, has driven the transformation of the state. And many of these changes that we identify, the different forms of collaboration, the state intervention, the public-private partnerships, all of that now, of course, comes from issues such as those. Okay, so what's really important, this is not perhaps the time of lawyers. No, we might have deep inside the idea that we now are responsible for global justice, because we were responsible at home, for a just theory of legal regulation, but worldwide that might not be our task anymore. So in fact, we just have to do problem solving. We have to regulate issues. And so these are the tasks that a regulator has to now fulfill. And maybe a lawyer can do these things, but maybe you don't need a lawyer for those. Okay, so if that's a pragmatic approach to go about the complexity of the world, then we have to ask ourselves what the role of law is in all of this. And that's why it's important to keep this other image now in mind, or to put it into play. So what do we really think law was? Let's just talk about very briefly about the first two definitions. We could say it's an institutionalized system that will help us to put rules into place and then see that these rules are implemented and see that these rules are enforced. We also have to have a process by which we can amend those rules, by which we can void them, update them, change them. And that's basically how we've been thinking about law for a long time. We could also have a non-institutionalized view, which is really important. We could imagine that we untie the relationship of law and the state and just say, what is the function that law fulfills? And that's a watershed, if we start to think that way. Because if the state is no longer the anchoring point, the starting point, and the framework with which we create and then contest law, then what could be taking the place of the state? That's really quite a radical question. And that's just simply there, blue on white. So, if law's function is to stabilize expectations, as some sociologists have been suggesting, then we could all live with that. But we do have that absence of the state. And so that's problematic. So with that in mind, why did this go away? Oh, here we are. With that in mind, what is the role of the law now? And it doesn't look very successful. And that's not just because of the last few years and a few outrageous violations of international bodies of law, but it's not really present. We find it in appeals to a legal normativity, but the traces of global law are in fact more difficult to find than at home. So it's ambiguous. Should it control the excesses of globalization, just as law should have or could have prevented or curtailed the excesses of finance capitalism in the last few years? Or should it empower individual entrepreneurship, liberalization? Should it give voice to those people that don't have a voice? That's the tension between definitions 3 and 4. How effective is law? Is law really the effective means with which you can address problems nowadays? And if you stick, as we mostly do, with definition number 1, then of course you run into the problem that the law attached to the state has proven highly ineffective, because the state itself has been undergoing such dramatic changes. Many people say that the law has become highly irrelevant. And that's not just due, and that's really important to see, and that's why you have to have these two things in the back of your mind. It's not only due because we have a globalized world now and states have problems to address border-crossing activities. The problem started long time before that. If societies continue, as societies continue to grow ever more complex, which of course is not just a natural process, but it's also a process that's tied to the ways that we perceive of that and give that an expression. The question is how can law be responsive to those changes? So we might say that that there's social unrest because employees are not well taken care of, no? And that's going to create a social paradigm of law. And we all worry about the social responsiveness of legal regulation. But we might soon find out that this is really too vague and too rudimentary, because that's not the only thing that defines a person in society. So as we try to develop laws that become ever more sensitive to pick up on what people's lives are actually looking like, then we find that there's much more than just being an employee. There's also much more than a gender divide. There's much more that defines people's very concrete lives. And if we want to have a rule of law that says all men are equal and that gives due process to all of us, then of course we don't want these to just be hollow words. But in order to realize them, we have to devise laws under the rule of law frame that are extremely responsive to the way that society has in fact become complex. And that's what's been tried for a long time, but it's also been contested for a long time, no? Because it stifles and it curtails individual freedoms. So at a time like the last 3 decades, where there was an amazing chance now to make private money, to delve and enjoy private liberties, many people would come to say the state's role is really not needed anymore. Well, the state has played a particular role in the first part of the 20th century, but now should take a step back and we take care of things. And the really important part about this is that this sort of neoliberal backlash against state intervention picks up on the same methodology that the progressive lawyers had always been unfolding. The progressive critique of the rule of law was it's too abstract, it's too vague, and it's too high above the heads of people that really need those norms. The neoliberals will say exactly the same things. And they also will talk about empowerment and about voice, but they will also say that the roles of judges should be driven back. No? And that's really important that there is this parallel. There's a left critique of state intervention which tries to sophisticate it, to make it better. And there's a right critique and says, sophisticated or better, it's already too much anyway. So we have to make a cut. At the same time, a complex society that has such a high level of division of labor and is so specialized will have a lot of private lawmaking. And that's not just an ideology, that of course is no part of an ideological debate over whether that's legitimate and should be allowed and how effective it is. But as a fact alone, you have tons of private lawmaking, which has basically grown out of societal practice. And now the theory that surrounds that private lawmaking, is it a backlash? No? Is it fighting back the state? Or is it just realizing that these norms are more appropriate? No? And in many areas of society you have those norms. A very important swan song was provided a few years ago by Luhmann, who is really behind definition 2, the late German sociologist. He said, and that's a very famous, really intriguing chapter in his book, last chapter of his book, chapter 12, he will talk about the role of law in globalization. And it's fascinating how sensitive he is about the functionality of law, which is to facilitate that people get a voice that didn't have a voice before. He says it's all about inclusion and exclusion. That's the main function that the law has to fulfill. But can law do that in a globalized world? And he's rather skeptical, and he ends his book in this very famous last sentence by saying maybe law was just an outlived European anomaly. And then the book is over and you think, oh my goodness, no, he better not be right. Okay, so now we come to the third matrix that we actually want to engage with, and that is how do we theorize the move from domestic law to global, to the global sphere. And as was already probably insinuated up until now, there's some feeling of anxiety that accompanies lawyers' assessments of the role of law, which is law is losing in effectiveness, it loses in scope, it loses in implementation capacity, And clearly, it's not in charge of things. So why is that? And that's often attributed, and that's why it's so important to just lay out what models of state such lawyers might be drawing on, because they say things are lost that we had to have. No, and things are clearly definition 1, and definition 1 is clearly tied also to number 2. So even if you have whatever kinds of layers of institutionalized forms, as in definition 1, it's important that the law fulfills that function, because the law itself might be tied to a particular idea of justice. But it's also clear after the 20th century that it's highly contested what this concept of justice should be. So what seems to be more important is that the law facilitates an ongoing public deliberation, of what the goal should be of a particular rule and its enforcement. So lawyers worry that the framework for these things are getting lost once you move to a global stage. And how has law been reacting? So and that's really important. Even if it's important to look at how the law has been reacting, because even if you're not international lawyers, that's what's so important about having a sociological analysis of the forms of state transformation. Globalization is not just a reality that people in international law 3 hours a week deal with. It's a reality that shapes law as such. There is no boundary in that sense between the domestic and the global. Now, the beauty of our project here, I think, is that this boundary, of course, is so firmly still in our heads. But it's not just that we are hung up or obsessed with national boundaries and with jurisdiction and with the nation state, but it plays an important role to identify certain ways in which we've learned to talk about law. It's really important, because the more we listen to those learning experiences, the more we might know that people from other places that now come onto the global arena, that they have those learning experiences as well, but that they are highly different than ours. And that's really important. So in that sense, as we try to reach out and understand the different starting points for people addressing global governance, it's so obvious that the same, of course, is happening at home. If we talk about if we talk about a complex society that's highly differentiated, we in fact don't need to talk about globalization to find the same issues. How does law respond to a society that's in itself highly differentiated, and highly complex? And if the law just presupposes that some people should earn more money or that they should have a day off, then that doesn't at all in any way capture the reality of those people's lives. And that's just exacerbated on a global scale. And that's why it's impossible to keep these things separate. You have to combine them. It doesn't matter whether you're just a tort lawyer and your friends are the people that do international law because they're just interested in it. Okay, so one of the ways that lawyers have been dealing with this, and one of the bridging terms which has brought more calamity than other terms, but that's really in a nice way shared between domestic lawyers and people interested in international law, is governance. And governance captures so much and captures nothing, and that's why it's often so dismissed. But the people that you encounter that just dismiss it, you should be wary of those, because they have very little to offer except for that they just shrug and say, whatever, it's just a fashion. Fashions often speak to a particular development. The development here, we've just tried to document. Governance, in fact, perhaps ineffectively, but responds to a transformation in the way that political control has been exercised. And that's why, even if we don't think it's a full definition that really tells us exactly in which way government has been transformed and supplanted by governance or by something else, that term is a provocation. And that's already enough. If governance provokes us to think about how the connection between state and law should look like, then the term has done enough. It doesn't have to do more. Okay, now let's look, and then we're almost done. Let's look at four stages of this. So we usually don't talk about what we've lost, because we all know what we've had. We as the people in the nation state. We just look at the mess and the dissatisfaction and the low level of political sovereignty that we find outside. And so I've just, each one of us can put a different list. We could just extend that list ad nauseam. there's different entities that evolve. No, there's international financial institutions. There's NGOs. There are international NGOs. There are questions over some of those large international organizations. Could they be made better? Could we make them more democratic? Could we understand the absence of a political government not as the death knell to the concept or the project of creating a global constitution, but instead might we be able to pull from these different already highly organized entities a constitutionalist agenda or a constitutionalist platform or some ground rules that could have the quality of a constitution. So we have those things, and it's highly dissatisfying, but that's the way we perceive of law on the global scale. And we do that because we know that we've had all these wonderful things before. We did have a hierarchy of norms. No? There was the supreme law of the land. There was legal stability. That was, of course, if you look at the transformation of the state, all of that is nonsense. No? Because you know that these things were always contested. But this is how we would portray it. No? The rule of law was a bulwark against arbitrary rule in a dictatorial fashion. We also really, really miss separation of powers. Although when we don't live in a globalized world, we really, really hate separation of powers because we know it's skewed, it's ineffective, and it's highly problematic. We also really worry about the lack of a constitutional order. But when we remember the fierce fights over parliamentary assemblies coming down on a really touchy societal issue with a slim majority, and society could now go to rest and say, it wasn't easy, but it's decided. Democracy now had another good day, and we will now try to see how we live in the next few years with this decision. No, somebody will bring it to court, and the court will then say, it's interesting to have had a parliamentary process that took years, but they just didn't get the constitution right. So we have to intervene and change things. So we don't really like the constitutional order at home, always, if we find ourselves on the losing end of it. So this is the world that we mostly deal with, but it's highly, highly incomplete. So what we don't capture in this depiction is 3 minutes. I need 3 or 4 minutes. Is the dynamics of this. No, there's no evolution. This is just a snapshot. So we now have to find a way to show how law has been changing. So a suggestion would be to look at some of the signposts that we can pick up over time that contested all of these things on the left-hand side. And what contested it was, for example, I just take one example that you might all be able to relate to. Consumer protection law in contract law. Now that's, when it first emerges, a really, really odd creature. No, it's a strange animal because it so violently seems to go against the grain of private autonomy, freedom of contract. Here's A, here's B. Neither of them was drunk nor sort of unable to see things clearly. And still, so they were both sovereign actors, just like nation states, by the way. No, the private law, public international law parallel is really important for this liberal mindset. Both of these actors were clearly able to enter into contract that should be binding for both of them. But we see that the judge and the surrounding discourse comes up with more and more qualifications of that contractual constellation and will say there are aspects that were neglected here and we have to put them on the table. So the conservative lawyer will say this is going to be a nightmare for legal formalism. It's going to be a nightmare for the second function of law, for the second definition of law. Because if you just add things in the name of the consumer, very odd term, who is a consumer? The little old lady or the stockbroker? Now that becomes really complicated. So that's one of the things. The other thing, other contestation that I just have to allude to very briefly is the idea of legal pluralism. So instead of just accepting that there is an officially instituted authority that will make laws, how do we reckon with the existence of a normative pluralism? So we could say, yes, unions, labor unions, make their own norms. But it's not a concern for lawyers because they're private. So we don't have to worry about those until we realize that they wield enormous power about the people that they represent. And in that moment, we begin to recognize that these are not just private rules that the state can ignore. The state has to understand now the legal nature of these norms. That's just one example. There's many, many more what legal pluralists become interested in because they ask, how do norms actually emerge? It's not just the question of how does the state become more responsive to the needs of society being regulated in a more adequate fashion, but how does the law find the already existing and highly efficient norms that are already in place without killing them off because they're not officially created. No, that's really important. And that sensitivity drives a lot of the legal development, of course, on the left-hand side, which means that if we take a better look now, after this 2-minute thought experiment, on law, we now know that the left-hand side law could never have existed and doesn't exist without its challenge, the non-law. Now, the non-law is really important. Is it all illegal? Is it non-law, or is it perhaps not yet law? No? Doesn't it really reflect more that we might say this isn't in our purview, but it might come into our purview? So is it not good enough yet? Is it not solid enough yet? Is it not authoritative enough? We don't know. But it's a combination of all of these questions. But the law, non-law tension is really the decisive driver for the development of law. So now, what happens here? No, that's the big idea. Because if we could now if we could fill this lower right-hand gap, then we would have a similarly productive, innovative, legal, civil society deliberation on a global scale. Let's have a look. It just becomes outrageously messy, no? It's similar to you being anti-globalization. So there's global civil society. I'm done now. There's global civil society, and that sometimes scandalizes human rights violations. Then there is outrageous setbacks against those things. Then there is talk about creating public spheres. There's a whole political philosophy around the idea of cosmopolitan governance. Then there's the idea that law comes from below, that you could actually mount a very effective critique of the powers in play and challenge them. Very important is, and that could be contested. I could just say generations of human rights. You might say, no, that's unacceptable. Generations of human rights clearly belong to the left-hand side. Well, they don't. Because generations of human rights has been, in the West, the longest time, a self-congratulatory but highly sophisticated way of expanding the scope of human rights. Because we say human rights have to cover much more. And we go on. We also then, just as a side note, we then embrace the idea that there has been progress in international law. Well, no. If we look closer, we find that this progress is extremely contested. And it's not just about generations of human rights towards universal happiness and justice, but there are alternative histories of writing the history of human rights. And so we have to look at those. Another example is global administrative law. Global administrative law sets out to solve the issues of the left-hand side, but it does so in a modest fashion. Global administrative law's modesty consists in not insisting that it's constitutional in nature. That's the argument. We would never accept this on a nation-state level. If you read the 1938 Storrs Lectures by James Landis, then you see that there is no thinking about administrative law without a constitutional dimension. Why would it be possible outside? If, of course, constitutional dimension appeals to the political framework in which we want to embed it. Lastly, transnational labor citizenship. What should that be now? Highly, highly ambitious program to try to combine political rights for people that are working outside of a protective system of their own nation state. So to what framework might we be able to attach political rights for migrant workers? And of course, inclusion-exclusion is the driving dynamics. Last slide, second to last slide, is the methodology that I would like to suggest. That seems to have emerged, I would think, is that if transnational law that Jessup had in mind was this, it was here, I would say it has to be a combination of law and non-law. If that reflection continues, then we might be on a good track. And that's what we could call transnational legal pluralism. And the difference to Jessup is that we don't talk about a field, because it doesn't matter if it's a field, but we talk about the methodology. And that's similar to you, a few decades ago, demanding that there should be a field such as environmental law, because tort law is not specialized enough. And that, of course, was refuted, because environmental law would be a new field, and what exactly are the boundaries of that field? It's really difficult. But if you say it's all about a sensitivity of how our legal order responds to complexity, then it doesn't matter if you call it environmental law. It doesn't matter, because you don't posit a field. You posit a way of thinking about law's evolution. And that leads you to the following. No, law shouldn't be so obsessed with fields and with giving things names. It should rather try to embrace the idea that its frameworks have they have been changing. So in that context, how do we begin to reassess law? And that might have to do with a methodology of governance, in fact. And in that context, we might see that law plays one role, particular role, also a particular kind of talking about governance. But it has to compete with no alternative ways of talking about governance. For example, those by economists and others. Thanks.
Thank you very much, Professor Zumbansen. Wait to join me at the front so you can the camera.
Could you flip back to your slide 30, or the table? This is my Zumbansen file.
Which?
Thanks, Gareth. I mean, a wonderful presentation of an incredibly complex paper coming out of a body of work that's itself incredibly complex, and it's an effort to try to navigate through that, including by the author, is always interesting to see and actually extremely helpful. I'm going to actually raise a couple of issues that I think flow out of something that you identified right at the start when you talked about globalization, but also about transnational law. It's just this slight embarrassment about what was not filled in, or was too much filled in transnational law, that there doesn't seem to be a there, that there's too much that's alluded to, that there's many things that it's not, there are many boundaries that are attacked, there are a lot of kinds of methodological mistakes that people seem to make, there are disciplinary divides that we have to ignore. And one of the appealing things about Jessup and appealing things about your work on transnationalism has been to use the transnational concept to really push us in this kind of mode of saying, are we falsely restricting our field of vision, our modes of analysis, our problem-solving capacity, our legal concepts? And so this idea of transnationalism is this kind of invocation of a kind of critique, a kind of rebellious move against dogmatic approaches to law, I think is very attractive. Here's the downside. The downside is like with globalization in the sense of intensification, of simultaneity, of 1,000 things going on at the same time. Everything seems to be in play. And in responding to a problematique that says everything is in play, the challenge always is, well, how does one avoid the problem of the Borgesian map that basically is not an analytic because it doesn't simplify anything, it just mirrors the world, and so you have a map that's essentially as big as the world. Or the problem of if you put too many colors together, what do you get? You get a kind of a beige, like a vague beige analytic. Or the last one, and I think this is a real challenge for folks wrestling with transnational movements and global activities, is kind of a feeling of that we all have attention deficit disorder, that we have to move so quickly that we're never actually able to stop and figure out is what's there, because we need to move on to the next thing. So for me, part of the response, especially as I get older and have no longer the capacity to hold so much in my mind at the same time, is I guess I've become more and more like an economist, which is a sad thing. In this sense, just when economists engage in partial equilibrium analysis, they hold many things constant, and they try to say, okay, here's the angle, here's a way of cutting the problem so that I can get a feel for what might be going on in other sectors, but I'm just going to hold a bunch of things constant, and let's see what the results would be and what kinds of patterns emerge out of that. And I guess part of what I've been thinking and was intriguing and thinking through your incredible paper is there a way to both recognize all the different fields and methods and disciplinary insights that you accumulate in this piece, which is just an astonishing mapping exercise, but can we hold some of them off for a while and focus on this sense of, is there anything distinctive that you think can recommend any of these kinds of approaches? Examples. just to take some off your chart of non-law analysis, the Global Administrative Law Project, or the Global Civil Society or Cosmopolitanism strands, one of which comes more out of law and others of which come out of other cognitive fields. Are these kind of, is there something about them that really recommend them to you as an approach that you might call transnational legal pluralism, or as an approach to give some content to transnational law? I guess for me, the challenge in thinking through this, and I'd really like to know whether your thoughts on this, is to me, transnational law itself has to be interrogated as itself containing some methods. Your suggestion is transnational law, to approach transnational law, one must use a broad, interdisciplinary method that you call transnational legal pluralism. And I guess for me, the query is there something more concrete or specific about transnational law itself? And here's 2 cents of that. Transnational. I guess one of the appealing things about transnational that to me is not the same thing as saying it's everything that's going on, is the idea of what it's working against, but what's contained in the idea of transnational. For example, the national. There's some sense in which the work that transnational law focuses on identifies that in our world society, as in domestic societies, there was attached to it a developed set of ideas about nation, relations between nations, tiers of political community and membership and identity that converged around levels. And that could be domestic, it could be federal, it could be international. The idea would be the concept itself is not wide open. The concept itself had a genealogy, and there were insights that were provided about how we think about being in the world and how we govern ourselves. And the transnational concept is actually urging us to think about and attend to the ways in which we think about our membership in different levels or tiers. Admittedly, those might have been tightly connected in the national concept of territorial conceptions, but not necessarily. And so I guess for me, one query is are there methodologies here that you list that in some ways get at that better than others? The other side is the law side. Just as an example, you quote from, I think it's Cotterill, who says something along the lines of, law has no methodology anymore, right? I mean, law's methodology should be, on page 156, to reflect methodologically law's own fragmentary, varied methodological characteristics, right? I guess for me, law has more than that. Part of what my interest has been in, for example, looking at conflict of laws, but others in looking at federalism, or others who look at contract law, or others who look at international laws, to kind of say, within those fields, there actually were conceptual tools, but also concepts of law that were incredibly intricate and that were developed over long experience. Example, in conflicts, notions of jurisdiction, of the separation of jurisdiction from governing law, of the separation of that from recognition enforcement, of issues about comity, about productive conflict, there's a whole sequence of conceptual advances that are part of the toolkit, but also the disciplinary apparatus of that field. And similarly in federalism, and similarly in constitutional law, or in contract law, like in private law, right? There's a concept there about how one relates, for example, public policy goals and private ordering. And I guess for me is a sense of turning to the huge array of methodologies that are possible to study complex global phenomena. Kind of raises this issue, well, do we just go around and figure out, do the economists have it right, do the sociologists have it right? I guess for me, there's a little bit of a reluctance to just do that. I want to see whether, and I'm curious whether you think, there's anything in law looking within itself, within its various trajectories that have been addressing the array of kinds of levels of analysis that the transnational concept pushes us to look at. Public and private, but multiple tiers, and their convergence around particular issue areas. And so I'm curious about, after you've laid out so magnificently all the possible resources we have to think about transnational and global problems, whether you can steer us a little bit, whether there's trajectories within there that you think are more valuable, whether there's something about transnational law itself that might discipline, the incredible variety that you describe here. And I guess lastly, and just as a query, as an example of the challenge that we're addressing here, I love chart 1. Table 1 was originally this one, the 1, 2, 3, 4, 5, and then I love table 2, which was this. And then when I got to table 3 on page 179, I had an extreme moment of not exactly heart seizure, but something like, so this is my field. So there's actual table that I kind of understand and has trajectories and has 5. And then there's this relatively nice 3-stage, 2-tier, whatever account of the development of the concept of state. And then we got this, right? We've got this 2x2 matrix, which I'm never too happy about, but a 2x2 matrix. But inside each of the boxes are an incredible variety of items. And I guess what I want a little bit more of is some sorting, some sense, because otherwise, my parents will be very upset to learn that this is the area in which I specialize, and so in that sense, I want a little bit of a kind of sense of, well, how does one, or do you think there is a way of narrowing or focusing where we're going to go with transnational law in the face of table 3?
Okay, so 5 minutes to respond to all of this. And then we'll open to the discussion, otherwise we won't have time to talk.
Is that why you want to do this? I can also respond later.
I think, because I've talked for 42 minutes.
But if you have some thoughts that you want to share, that might just help spur some discussion.
Yeah, I've talked enough. I'll respond to those really nice questions in as good as I can, but you should really throw more up and respond to both of us, really.
Okay, well,
that's more important, I think.
Any questions? Yes.
I want to know if the pair thinks there are any methodologies of law that are particularly useful.
Oh, useful.
See, I have to leave, so I'd love to hear.
The only girl you have to respond to him.
Okay, so
There's
that's
no
the
easy way
question.
out there.
Who gets a star? In this box, who gets a little star?
Interesting. Okay, I have 3 responses to that, because I saw that coming. One is, and I'll start with the most tedious one first. I'm so engaged in trying to in speaking with others that I find it more important to first lay on the table what we should be aware of when we talk about this kind of stuff, and it's just then we run out of time. We run out of time, and I run out of wisdom, and I also am not old enough yet to then say I like one more than the other. I also have to say that in the profession that we are in, and that some of you might go into, the teaching function of this is not to tell you which one I like, and that might just be totally wrong. But I've become so accustomed to this, and now of course it comes into a different layer. So if I try to identify where my heart beats stronger among those things, then I realize that I don't want to share that, because I don't like teachers that tell their students where they stand. I think it's more important to expose us to how much we still have to all learn, and that's what I always thought teaching is about. But of course, there comes a part, and that's why it's not just simply said, not wise enough yet. There's 2 great approaches with which one could do those things, and that's basically what I think one can discover. One, and that's really the number 1 and number 2, and that's closely tied to 3 and 4. So let's say you develop a theory that will become incredibly dominant and that will merge into global civil society talking cosmopolitanism. And you do that against the horror of the Third Reich. And you do that in the context of post-war Germany, that you develop a theory about democratic re-education, about dealing with American values, about integrating the country into the West, which also meant shutting it out from the East, because the Cold War was flying high. So if you embrace that theory, then you will always ponder on deliberation. You will always ponder on historical remembrance. You will always ponder on a context that's really important, where you come from. And you will have to appeal to the will the reciprocal will to understand each other. No, you will have to appeal to communicative reason, as Habermas formulates it. And that theory is, of course, outrageously, is exceedingly criticized, because it's understood not to be sophisticated enough for a complex world. But the lack of sophistication is owed to its genuine background, which is that it's developed out of a particular context. And that authenticity of that universally inspiring theory is also, of course, its Achilles heel, because it just also is local. No? So in that sense, to embed it in a particular political historical context is one of the theory's problems. So the more now Habermas, and if you pursue what he does now at 81, the more now he tries to globalize his theory and to take all of this contestation and different localities on board, the appeal to communicative reason, of course, begins to fade. But he mustn't allow that. He doesn't want to allow that. So he will just insist that it has to bridge all of these divides. And then, of course, he's challenged by fundamentalism, by secularism, and how to make off trades. He says, well, it's difficult, but that's what we do. Okay, now you switch and you take a whole different realm of thinking where you don't worry about your beating heart, because that's really not in the forefront. You also don't worry about a particular national history. Those things are just elements that you find on the way. That's the other side, the Luhmannian side, the sociologist who studies the differentiation of society. For that sociology thinking, the world has always been world society, which is really, really important. There has never been a national society, except for that historians have been tracing the emergence of statehood and have been describing society for some time in terms of nation states. But it's really not important, more than it was important at a particular time, but it shouldn't govern our understanding. That's why the functionalist approach to understanding society then has a particular place to play for role, for economics, and for science, and for religion, and for politics. Politics, for Luhmann, is for some time associated to the state, but it doesn't have to be. It's just a historical way. Now, that is really a very, very sober, enlightened, well, not enlightened, because that's Kant's and Habermas's term, but it's a sober and almost cynical turning away from concrete historical experience. Now, both of those have to coexist. And that's the challenge. And that's why all of these things are on the board. So against that background, then, I would say, I could now say that my sympathies lie with Habermas. Because I still believe that's why global civil society is on top. But if I read the work that people put forward, I shudder at the thought of how early they talk about the we. That is something that would never happen to the sociologist who doesn't presuppose Western liberal society as the non plus ultra. And that's why you have to combine it. But of course, if you go the other way and you don't even allow yourself the political claim to form a we, then of course you get these anxieties. So is there no we? Is there no chance, to rock the boat somewhere? Is there no? So yes, anti-globalization is ridiculous, but I still am anti-globalization. So that has to be possible. No? And that is a combination that makes it so hard. And the last thing why insisting on this methodology is so important, and that I underemphasized, is that parallel between progressive and neoliberalism. If we work through the state as lawyers, as sociologists, political scientists, and we try to adapt the state and democratic governance to a more pluralistic society, we will try to improve the way that the law responds and picks up people where they need to be picked up. But the last 30 years, that went terribly wrong. The most influential law and society movement was law and economics. And that is just so important to realize. Law and society was in itself a very encompassing, vast, and probably overly vague, but it was clearly a progressive, left-leaning project. Well, the really, really influential, sophisticated law and society methodology, dominant all over the place, has been law and economics. Now, how do we react? And that's where it's important as lawyers to react through a combination of methodologies. Because if we just say we want the state back, they will say, well, let's have the state back, we'll do some bailout. That's exactly what you see now. No, because it's a quantitative assessment of more or less state. Because the neoliberals, they don't worry about the qualitative stuff that we as lawyers should be concerned with, which means what kind of state and what kind of society, and where's the tension between those two. The neoliberals have it easy to say there's more at some point in time and there's less state at another time. That just flies in the face of more than 100 years of analysis of how regulated this allegedly private sphere of the market has always been. Is totally obvious. But the neoliberals don't even have to worry about those things, because they will come with a very clear-cut definition of what the market does and what the state does. And because it has become so intricate, because institutional economist thinking has become so influential and has taken so much of this private regulation on board, it's really important to work out more those methodological starting points, and then to identify what the normative frameworks are that inform those methodologies. So we can be Habermasian, but I can be Habermasian in nature, but I still have to be really tough on not being cozy too quickly. And much of the cosmopolitan writing yearns to be cozy again, and yearns to try to make that happen. And that's problematic. Also, and that's really important, if you grow up in a sort of crit environment and you take all of this on board and you say, I'm a crit and you haven't done the work yet. And the work, the labeling will come at a later point. But it's all of these things first that you have to work through, and then see if you have anything else to add. But to say, I want to politicize this process, well, it's not so obvious anymore how to do that. And that's why overly premature, what I would think is premature, too quick references to the state or to political processes, well, that's why it's so good to combine the domestic and the outside analysis. A local administrative lawyer would just laugh at those things, because he would say, whatever these global admin lawyers talk about, constitutional ambition, administrative law has been always very political, very down to earth, extremely implicated in the doings of society. So, of course, we've had framework laws and parliamentary deliberations, but the action has been within the administration. And that's just repeating itself on the global scale. So it's really important to make those loopings back into the domestic. So no.
I guess I have a question. This question is coming from a big, evil, analytical legal theorist. I'm wondering what this concept of transnational legal pluralism really adds to what we have. You started with Jessup saying, Jessup talked about law. He says, we tend to understand law in domestic terms or in international terms. That doesn't account for everything that we should call law, or that is really law. And so we have this category, transnational law. On the other side, we have this other concept, school of thought, way of thinking about the law, way of thinking about norms, which is basically normative pluralism, right? And some of these norms can be more or less legal, so we could possibly think about something called legal pluralism. Now, all these international, transnational norms that you're talking about, they're just other norms. They're norms that they're norms that we should be thinking about more, norms that we should be trying to develop more or study more. They're just other norms that fit under the umbrella of normative pluralism, of legal pluralism, right? Legal pluralism is not a box as domestic law or international law would be. Why do we need to add this transnational? Why don't we already have what you're talking about, at least conceptually? Because you said at the beginning of the paper, I want to make the case for this new concept and why it's important.
So that's not so difficult, I think, unless I just am entirely mistaken. But the first level here, the first two columns on the national level show that law can only be understood as legal pluralism. Legal pluralism comes as a provocation. No, it doesn't suggest. It might suggest that it is against the established order. So it might have an usurping, resistance drive to it. But it might also just be an observation that there is plural normativity. So it's just a different depiction of law. And it's really important to see that from a legal pluralist world, you don't have this dividing line anymore. It's always the law, non-law differentiation. And that's really it's relatively easy to study that if you look at the fields in which there has been a lot of private legislation in the last few years. So either fields that were regarded as important for market self-regulation or for international competitiveness of nation states, where governments that said many of these issues are so deeply embedded in political conflict, if we just let the market decide, we might be able to develop a regulatory framework that makes it easier for our national actors to compete and to operate with others around the world. And then scholars said, so is this law? Are these privately made norms and codes of conduct, best practices, are they law or are they not law? And whereas lawyers get entirely hung up about this, others would just say, what functions do these norms fulfill? But that's not enough for us, because we don't just like definition number 2. But we also know that number 1 is not the answer to the anxiety that the second definition has. And that's why the third and the fourth become so important, because that tells us what do we want to do. So the legal pluralism critique or approach to law is really to open a debate, and that's clearly so Habermasian, because you see now my guards have fallen, to have a debate among a yet to be defined group to ask why should there be a rule in the first place? What kind of societal utopia do we have, in fact? And that's really central, because if you look at the way that this whole privatization and private lawmaking debate has been going for decades now, it's always that at some point they will say these laws have to be codified, these norms have to be codified into law, or these norms crystallize into law, as if that just happened. Or they would say there's a private committee and it makes rules for market agents, and then they say, and these have to be regularly updated according to the needs or to the pressures. And you wonder what that is. Is that a separate democracy? Is it an alternative statehood within a state? Totally undefined. And that's, I think, what legal pluralism breaks open, because it asks for the normative framework in which this trade-off between hard and soft law happens. Whereas nowadays we just learn that the good sort of official accountable laws are hard, whereas the chaotic, anarchical, often private norm-making is just soft, and eventually it can become dignified and hardened. That's just nonsense, because history tells us it's always been a trade-off between hard oppressing law and sometimes emancipating, hopeful and promising soft laws, and sometimes just the other way around. Because it's the other way around, 3 and 4 is so important, because there is a social theory behind hard and soft law. It's not just something that you take for granted. But if you follow the debates around hard and soft law domestically and in international law, it's all about ideology. The thing is totally taken for granted, because nobody talks about the social utopia behind those. But of course everybody has one. And that's why I think it's so important to say you don't have any of these things to sit on. It's legal pluralism from beginning to end.
Can I just really briefly, so Francois' question about what is the concept of transnational legal pluralism, add to it, your response was the concept actually takes down the law-non-law distinction. That's the use of the concept. You then say it enables the discussion that you say, yeah, this is where I'm actually a Habermasian, is actually what you think is at stake. It's not the divide law and non-law, it's something else. Is that right? Because the moment in the paper where this seems to me to come through is on page 184, when you try to talk about legal pluralism as methodology and as theory. And as a theory of law, you do start to speak very much in the mode of saying, whatever we call it, in whichever social domain it's occurring, we have to have, there is a project of constructing a theory of law that has both formal and substantive components, and in the substantive part, you get very close to discussions about justice, and specifically in a
very weak moment.
No, but there's this sense in which the concept itself of transnational pluralism is only getting you to this point where you then say there's a theory that we have to develop here about the normativity or whatever you want to call it, and it seems to be that that's legal. And so then the question is, what's the progression here? Is it the transnational legal pluralism concept opens up another conceptual set of theory issues that actually engage you? In which case, this is like this is like the prologue to a program of transnational law.
Yes, no, clearly. Who knows if that's over-exaggerated to always refer to this matrix as the stuff we've known so far. But as we are still in Western, northern parts of the world, are still the ones that have defined the way that law progresses and its universalist aspirations, this might just be, in fact, an invitation or a provocation, to talk about the same way that we've been undoing the legal hierarchy in our nation states, because we've been discovering that it's in fact not just about easily identified political goals. No, we want to help a particular part of society to become as others, and we still struggle in a ridiculous fashion. In fact, if a Martian came or somebody in 50 years and we would still be fighting about affirmative action, they would say, what a barbarian society this really is. So we still are quite at the beginning on a domestic level. But on a transnational level now, if people are in fact now operating in ways that Jessup clearly had already in mind, and workers are a prime group for this, where you cannot re-domesticate their lives and then say hopefully they get well treated in a particular jurisdiction, but you have to come up with a post-national concept of political sovereignty, rights, and some kind of legal framework. That's where that transnational legal pluralism comes in. It's radically open, and it probably the only methodological basis for it is that it has to take those different conceptions on board, whether that comes from post-colonial historical writing, whether it comes from literary critique, who knows. But it's clear that the way we talk about the generation of rights has to be a different one than this social progress paradigm that we've had in Western welfare states for the longest time. And it's not clear yet from where that should come.
Does the project of legal pluralist methodology, though, as you develop it, can it be a project that leads to some kind of a reconstruction of a utopian world that we want of some kind, or is it bound to be a critical project? Because when I think about the idea that you talk about at the beginning of the paper, about how the point of legal pluralism is always to go back and look at how the law-non-law distinction is made in any given context, it seems to be that you end up, there's sort of an infinite regression of being able to, of going back and forth on the law society or law-non-law paradox. And I'm just sort of wondering, once you get committed to following that paradox, is it ever possible to stop?
So you keep asking me that question, all of you now. And either you don't know, or you all know and I don't. So I would think you all do know, but I don't. Okay. And it's just that I'm too blind to see. But I'm so engaged and almost, probably, pretty much passionate now about this infinite regress. But it's, and I don't know, the illusions that come, or the images come to mind that you, again and again, are in circles of debates where people identify these new projects. And these projects are mostly entirely ahistorical. They negate any discourse that has taken place before. They undo all of the critical work that has been done so far. And so, it's such a big job and so much work already to then just retell and put on the table again that this already has been going on for a long time, that I might just not, I'm not the person to come up with what should come afterwards. I don't know. But it keeps me busy already. But this is not satisfying. It's also now not satisfying for me because many of you seem to have that query. So where do you see that? Do you know? What? Do you have heroes here, favorite things? I don't know, I just find that a bunch of just proposals on the table. I clearly like transnational labor citizenship. I really like that somebody says, I'm very good in sociology of employment and labor relations, but I also am a political philosopher. So I want to connect issues of politicizing global labor migration with political philosophy, perhaps going back to Hannah Arendt and others. I like those things. So they become more sophisticated. And that, of course, clearly puts me into a normative camp. And so, yes, maybe I believe, on a warm night, that this could go somewhere. But who cares if I think that? No, it doesn't really matter. Lisa.
I would love if you said more about number 5, the parasite. Oh, more on the parasite, please. And also, I think it's not just us who are asking this question about, is there some way to move past the dog's breakfast to something that's a bit more coherent about how change will happen in a way that will lead us to something better? Because isn't there some striving, even in the array of processes that are going on around all this array of issues? There's some striving for some unity again, I think, and some sense of constitutional order when we see things like the big discussion about shifting from the G8 to the G20, right? And that somehow this group will meet and this will have some kind of trickle-down governance effect that different countries around the world either will or will not adopt a bank tax, or they will or will not engage in stimulus spending, right? There's a craving, I think, there for some kind of unified constitutional order.
Yeah. But in all earnestness, only sheep need a leader. I don't know why we should feel better about somebody saying that the G20 is in fact a qualitative step forward. Our profession, and that's why we spend times in ugly rooms, being handsomely paid for that, to put out critical frameworks for people to stop talking rubbish. And if we communicate that to the outside, that things are in fact a bit more complex, then that's already quite a critical project. So, for example, I'm now employed to read Samuel Moyn's History of Human Rights. That's a very big privilege that I can spend my time not feeling that this is luxury, but I can this is part of my duty now. So I read this, and I read a lot of other things that tell me that the accounts with which we have been assessing the G20 and Basel and all these other things that we now toy around with, whether they are actually the right way to conceive of those things. And what this tells me, this reading, is that the way that we've been ever more complexifying that shift between, on the left-hand corner, between national and global, is in fact outrageously parochial. And so we have to complement that. And that's what that's what is being done right now. And so you could spend your life thinking and theorizing the generation of human rights. That is clearly a truly fulfilling enterprise. And then to have somebody to come to a point where you say, this is just a very, very narrow way of talking about this stuff. There's alternative ways of doing it. And then suddenly you find, of course, there's precursors to that. No, it's not just the historian telling the alternative story, but there's all this other human rights critique. So you can build it all into this. But then you're a human rights lawyer. So you're not a global financial regulation lawyer. But what happens today now is that you have to be both. Because if you are both, then you actually know what kind of concepts you have of what kind of society you want to put forward. And that's why that critical project builds out of those different strands. Law as parasite. Now, law as parasite could be entirely wrong. I don't know exactly. Law as parasite is, of course, meant to capture the way that the law will take on board different conceptions of justice, different conceptions of effectiveness, different conceptions of usefulness, different conceptions of that it got a job done. Now, if you see how law, that 3-letter word, progresses and how it's been used in so many different contexts and how it's continued to be used, appealed to, abused, instrumentalized, then you see that it clearly has been playing that role, no? But now, parasite might be wrong, because it's in fact all the others, that take something that we hold dear, because we are in this room and not in Schulich. So we are here and we think that there's something inherently normative, perhaps, or sticky to law that might hold the constant decay. Who knows whether that's true? But I would think that yes, I think that a historical interpretation or the idea of law as stickiness, law as sand that you throw into the machinery to ask what actually is going on here, and not just law as a facilitator of unquestioned assumptions and goals that are just being thrown out and taken for granted. That combination is why I think Parasite might work. No, but it also is to teach us some modesty, because if you look at the global governance projects, they are doing very well without any legal input. No, you don't need lawyers. Lawyers are not the first experts that are being called upon to design a global governance structure. No, it's other people.
I have one thing that comes to mind. I've come across this term before, chaotic, kind of striving to get walking a fine line between the order and the chaos. And it seems that the point that that's coming across to me is that this ever-increasing complexity sort of dictates a situation where we can't have a specific utopian objective because there's no way to possibly extrapolate what that would be, given the rate of change and perhaps caused by globalization, I'll say. Is that?
Okay, the only thing that's odd about such an account is to historicize it, no? And to assume for 1 second that we are now in a worse state or in a less certain state than we used to be. I just don't see why that should be the case. No, I would understand that the project of law has always been that, to bring order into chaos, for example. But that could be in a very definition 3 sense, or it could be in 4. And it's never changed. So globalization is just one different form and one advanced form to talk about the complex environment in which you try to assert legal normativity. But that's it. But it's not good to romanticize what has gone on before. In that sense, historical work is really insightful if it traces the history of defeats, the history of compromises that were struck, the history of forgetting. Much more important than the triumphant moments that we keep celebrating. That's why when you introduce this correlation between globalization and law, and you identify the classic international law signposts, it's relatively straightforward and uncontested. But once you ask whether that's actually tracing, whether 1948 is the most important date in international law, is that really so? If you start to look for alternative dates, you begin to tell an entirely different story. And that's no promotion for this law school. That's also one of the great differences in this project that's being done here and, for example, in Michigan. So if you study law in Michigan, you have a mandatory course in first year in transnational/international law. And that's so that the American students that have gone to an Ivy League school don't leave school not knowing what the United Nations are. But that's clearly not enough. But if you do what we try here, to engage with chaos and this contestability, and you say globalization and the law, imagine people like Robert Way and I, we go to conferences in Europe, and people say, so what do you teach? And Robert, at least, he can say, I teach conflict of laws, and then fine. So he might also mention globalization and the law, but then they will already think, where are you? This is like insane. It's not a legal field. This shouldn't be a field taught in law. And I, thank God, can also say corporate law, and that's fantastic. But then if you say globalization and the law, I really like that even more. It sounds entirely, unwieldy. But that's a huge project to try to theorize what that could be. Because there's so many different ways of doing it, but it's clearly different than just saying progress in international law, because that's just humbug.
Super. I'm going to ask this question in another form yet again. Where do we go from here? What's the next step? What would be your next step? Were you to countenance this? Is it just to now focus on one of these different labels, like a global administrative law? Is that now the framework is there? Let's move on to the kind of the practical focus on certain norms, try to understand how they arrive, what they mean, what they should be, etc. Or is there something more? I'm just trying to see what it does for us, right? It's opened up the field, but legal pluralism had done that for me a long time ago. Now you've just added transnational to it.
That's a very harsh critique.
No, sorry.
I have feelings too.
We'll go for a beer afterwards.
No. I'll go with my
Coffee, water.
I'll go with my cynic friends. We don't talk about feelings. Okay, so where do we go from here? For example, one thing that I think is really worthwhile to do is to challenge global administrative law by the following. So global administrative law has created a project which is incredibly prominent, but is entirely ignorant of the administrative law work that has been going on before, which is really odd. So administrative law has for a long, long time been a rather local affair. No? There's very little comparative administrative law work. There is some, but not much. Why is that? Very strange, no? Because public lawyers work in a particular way, and that work didn't seem of interest to global administrative law scholars. Now, what if we did transnational administrative law? How would that look like? Well, that would look like that we try to identify the stickiness of national historical perceptions of administrative governance using that table, for example, and tracing the role of administrative law in a particular political economy. Once we trace that, we can be much more sophisticated in identifying the power dynamics that are, for example, at work at the WTO. And why is that not being done? I don't know. But for example, if you look at the foodstuffs and GMO dispute that has occupied us for a long, long time, well, that only makes sense from a transnational administrative law perspective. Because if you understand the culture of regulating, but also of eating and of living in these different places, then of course it becomes clearer. Now, there is some of that being reflected on that level, but by far not enough. So if we really trace the transformation of the state idea across different countries and then said, these countries now, what would they think of global administrative law and how do we verbalize that on that level, we would have a much richer and more thicker account, and it would clearly just not be satisfied with the last stage of theory, which I hinted to, which is global administrative law has been pushing those boundaries of accountability, transparency, and participation. But when asked about the normative outlook, exactly your question, so why do you do all of this? What's the greater vision? They would say, that's not our job. They would say that. Nico Krische will come here in 2 weeks. He says, that's immodest, and that's not for today. Okay, so that's really an important work. Another thing that we would have to do, you take the account that the World Bank has had in many ways towards its development policy. There's a very strange inherent time sequence in there. So what kind of rights have to be installed and implemented today, and which ones can come tomorrow? No, and there's clear focus on market functioning rights today, and the rest tomorrow. Now we already know there's tons of work around the nature of these rights and how we can complement them. But what I would be interested in, that's why I like legal pluralism, is to understand that time sequence. Is it really about 2 years from now, or is it really about a different societal utopia? And that I can only capture through a legal pluralist lens. Because then I will ask, what are the norms that are already in place? What are the norms that we sort of have to work against? If you just depict it as there's corruption, and we have to get rid of this, and that's, no, you have contract and property and criminal law. And then you have an anti-corruption task force, and eventually you will begin to build public schools. Well, that is really not very complex. No, it would be a joke to do that at home. But elsewhere, no, it has worked quite well. So one begins to sophisticate those agendas and asks for those things that are often described as, simple. It's either more or less, or not today, but soon. That's not how things work. And that is often, and you can just put the term rights into the center. Because what makes that right? It's a social utopia that's captured in that. It's not, and that's, if we continue to allow that rights are just being instrumentalized gadgets, that a society will be given in order to fulfill a certain function that is usually pro-market, well then, that's a terrible failure of the kind of rights critique we've already been working on for a long time. And that rights critique is inseparable from an understanding that is born out of legal pluralism.
Professor Rihan.
All right, so I like the messiness. I don't have any problem with the messiness. I've got two questions. One is, do you think the kind of reaction that you're getting here, are people reacting to the transnational? Are they reacting to the legal pluralism? Would you get the exact same kind of response in terms of the concerns about the messiness from anyone who came, if anyone came to do any kind of presentation on legal pluralism? So that's my first question. And my second question, because I don't actually have any really serious problems with any of this, is a kind of picky question, and it's about language. So there's some language in here in the paper about citizenship. You use the term citizenship. When you talked about Habermas, you kept on being self-reflective about the we. I wondered if you could speak a little bit more about that.
In what sense?
Well, in what's causing the concern about the we there? Do you think that actually the legal pluralism can help with the we issue there? And is there some kind of connection to this issue of citizenship?
Okay, so the first question is really difficult for me to answer because I would have to be a mind reader, which I am not. I read papers and books, but I don't read minds. So I don't know why you are so upset. No, if it's about legal pluralism or transnational, I could imagine you would have a right to be sort of concerned with my lack of talking more about transnational. In fact, I've been taking much of that for granted because I think the work trying to define what is transnational has been going on for quite a while now, and I'm now interested in tying it back to this kind of law and non-law critique that I think was really important in the nation state, and that's why my emphasis is more on legal pluralism now. But I've always thought that transnational law is a method of understanding distinctions, between how do we define that something is of domestic concern or international concern. And that's a particular way to try to break down, but not to overcome distinctions. And for me, the transnational law as method is centrally about this. It's not to get rid of them, but to understand in which sense particular legal cultures hold on to public-private distinctions, how they operationalize them, how they work through them. And I find that extremely productive to work in distinctions. So that's really important. And that has much to do with what I think is the paradoxical nature of law. No, law is binding because we say it is, but we also appeal to a bindingness in law that sort of we find already before us, something that's not possible. So that's part of that. Now, in terms of the we and citizenship, that's one expert talking to the non-expert there, because I'm intrigued by people that are really worried about the moment in time, today, tomorrow, of constituting the we. So in the Habermasian context, it works perfectly if you go as he does, and you combine public and private autonomy. But that always presupposes a certain group that is involved in that process. And those that are not involved, there is a duty to involve them, so you reach out to them. But that is really only in a very narrow context. So I wonder how, and that's of course only one dimension, but one dimension is about participation and inclusion. The other thing, of course, is that, and that's reflected a lot in the debates about European citizenship, in what sense can we really make sense of the idea of citizenship, that is the exercise of political rights that you should have been the author of, in the Kantian sense, in a multi-layered, highly decentralized and highly problematic, in terms of political sovereignty, system. And that's why the idea about European citizenship has been for the longest time a thorn in that entity. But it's been extremely productive as an idea to push it. And that's how I understand it.
Any more questions? Okay, seeing none, I'd like you to join me in thanking Professor Zumbansen for a very mind-expanding paper and Professor Wei for a very thoughtful response. Thank you very much.